All right, BADM 107 students, about another 20-minute video, and you'll be finished looking at my bobbing head with the exception of perhaps some review lectures before the final exam. We're looking at one slide only, the last one in the chapter on miscellany. We've already covered insurance, and you've seen the video on intellectual property. Well, this one is on estate planning. Very early in your life and your business career, you should consider what happens to your assets as you begin to amass them. If you pass away, you want your assets to go certain ways, either to beneficiaries or charities or whatever, right? So there's really 5 documents that you should have in getting your estate plan together. And these will encompass not only what happens when you pass away, but before you pass away as well, because there's very significant factors that have to be taken into account there. The first document that you want to have to get your estate in order is a last will and testament. And it's a bit of a black topic, thinking about your passing away. But in these days of pandemics and COVID-19, this thought is probably on a lot of people's minds. If you do not have a will, when you die, the law of the province of British Columbia says all your assets should be assembled and sold, and then the money divided up equally between your rightful heirs, okay? The next people in line, by relationship. So you don't want that to happen because, for example, my father, when he passed away, wanted the family home to go to his eldest son, me. He had one son, 2 daughters, but by tradition, the family home went to the male, right? And so he wanted to put that in his will, and did so. I told him I didn't want that to happen because I didn't think it was fair to my 2 sisters, but he insisted upon it. So I talked to my 2 sisters and said, okay, when Dad passes away, the house will be sold and divided up amongst the 3 of us so that they didn't worry, and they trusted me. So he did that, and then he had some other things that he wanted to give to my sisters directly and things like that. And so you do that in a will. If you don't do that, then everything has to be sold and the money divided up amongst your rightful heirs, because if you have no will, the people that take in accordance with their relationship are heirs. If you have a will, then they're termed beneficiaries. So the last will and testament it's not even a legal document really until you pass away, because then it becomes binding. Up until then, it's a piece of paper with your wishes on it, and you can amend it at any time, or you can rip it up and throw it away. So that's the last will and testament. If you want to prepare for the possibility that you may be incapacitated during your lifetime but not dead, that's another factor, because with COVID-19, if you become suffering with it, you could be incubated and put on a ventilator. And for a period of time you're on the ventilator, you're unable to take care of your affairs. I talked about Shane, my client that ran the business and was making money hand over fist. But if he passed away, because he was the business, the meager little assets divided up amongst his children would be insignificant. But if the business could be sold on an ongoing basis, then there was real value there. But if he became incapacitated or passed away without having some provision for the business, then his family and kids would suffer. So I suggested that he have a power of attorney and appoint someone, who could step in and run the business. Then the business could be sold on an ongoing basis. And he had a manager that was very much involved in the business and very good at it. So he gave the manager the power of attorney so that the manager could run the business, and then in the event that the manager wanted to buy it, the manager had the right of first refusal. That takes care of the business, but what about your personal matters? So you don't want the business manager paying your bills and things like that while you are incapacitated. So you might want to have a power of attorney of a personal nature, appointing some family member to pay the hydro and take care of the banking and things like that. All right. So those are the three documents. Now, the powers of attorney are express agency relationships. What's that mean? Remember back in slide 180 when we were talking about corporations, an agency relationship was when a principal authorized a person known as the agent to bring the principal into contracts with third parties. Well, it's not even necessarily contracts with third parties, but you can have a power of attorney that allows someone to do your banking. Okay, so it's really taking care of contractual matters, your relationship with the bank. But they can go in and do the banking, and they can, buy groceries for the house. They can pay the taxes. They can do all sorts of things. Express agency relationships. Here's a little bit of business advice. If you decide to get a power of attorney so that you can appoint someone, you should always go down to your chartered bank at least, show them the power of attorney and say, will you accept that? Because I don't know what they do now, but the Hong Kong Bank of Canada, HSBC, that's where my father banked. And I took the power of attorney in because my father didn't pass away. He lived on Gabriel Island, but they took him down to a hospital in Victoria because of a heart problem. And so he was going to be down there with his wife, my stepmother, and so he wanted to do the banking that he had to do down there. So he wanted his bank account transferred from Nanaimo down to Victoria, and I had a power of attorney executed for him, and I went into the Hong Kong Bank of Canada, and I showed it to them. They said, "Oh, I'm sorry, we don't use those. You have to use our form." And I said, as politely as I could, "No, this is the Power of Attorney Act, or form authorized by the Power of Attorney Act of British Columbia. So legally, you have to honor it." And they just said, "Well, no, sue us." Okay, banks are bigger than our governments, and so they just said, "Well, you go ahead and sue us, and if the court says yes, then we'll use it." Well, all I'm doing is transferring his bank account, for crying out loud. I wasn't even taking business away from them, so that attitude is like bizarre. But am I going to take money of my own or take money of my father and fight a $35,000 court case to get a bank account transferred? I don't think so. And so they can get away with that, okay, because people just go, "Oh, okay, whatever." So they gave me their form, and I had to go back to the hospital, get another lawyer to come in to witness my father's signature just so I could transfer his bank account. It was just stupid, but that's the way we are. So you always want to check to make sure the banks will accept it. And generally what they do is they take a copy, keep it on record, so that if your representative comes in with or your attorney rather comes in with the power of attorney, they can compare the documents and then deal with it accordingly. All right, so there's three documents. The last will and testament, which speaks from the date of death, which means it becomes valid only after you pass away, and the powers of attorney, which cease to operate with your death, but up until the time you die, your attorney is then able to do for you anything that you can do for yourself. The fourth document deals with medical situations. If my wife went into the hospital right now and she was incapacitated, I could not go in and give the doctor instructions. Okay. Because the doctor will say, "You have no right whatsoever to speak for your wife." A few years ago, BC brought in a statute what other provinces have called the Representation Act, whereby I could, or my wife could authorize me to be her representative to make medical decisions for her should she become incapacitated and not be able to do that herself. And I'll give you an anecdote which explains the dangers of not having one of those. Before we had those kinds of relationships or documents in BC authorized by the Representation Agreement Act, my stepmother, my wife's mother, my mother-in-law, lived 2 blocks away from us in North Vancouver. And we were constantly visiting each other. One time she came down and we had a nice dinner together, and she went home. And then at 2 o'clock in the night, she called us and said she could not breathe. So we whipped up, grabbed her, and fortunately we were 3 blocks away from the Lionsgate Hospital in North Vancouver, and we got her into emergency. They took her into the emergency room, and the doctor came in and said, okay, there's a blockage in her throat. We're going to have to put a tube down her throat. And of course, Mabel was very anxious, as we all are when we go into the hospital. And the tube is like putting you on a ventilator. Her blood pressure shot through the roof. And so the doctor said, okay, we'll give her some blood pressure medicine. Now, my wife was with her at that time and said, no, you cannot give her that blood pressure medicine. That will kill her. She's on a different kind. And the doctor said, who is this woman? Get her out of here. And kicked my wife out of the hospital and was going to administer this blood pressure medicine that Mabel's doctor had said she could not use because it was too dangerous. So she was using a different kind. The doctor just kicked her out, like he knows better. You know, doctors are gods. And he would have given her that medicine, and Mabel would have passed away. But we have a really weird family doctor. She is a very strange lady, but really good at diagnostics. The other really weird thing about her was she came to the hospital. Now, usually, if you're going into the emergency ward and you called your family doctor, the family doctor would say, well, okay, make an appointment at 9 o'clock tomorrow. Right now, you're in the emergency ward, and there's lots of doctors there, and they can take care of you. Okay. Anyway, our family doctor came into the room at that exact moment, told the administering physician to back off, that she was going to take over because the medicine that he was going to give her would have killed her. Okay, so a few years later, my mother-in-law came in and said, now we've got this statute, the Representation Agreement Act, would you please draft one for me, authorizing one of my daughters to act on my behalf in the event I can't. Okay, so now if it turned out that we were moving away from downtown, or from North Vancouver to Gibson's, and so Mabel gave the representation authority to her other daughter that lived in North Vancouver. And then that means that if she went into the hospital, Kathleen's sister could go down there and say, I'm the representative, I can speak for Mabel if she cannot speak for herself. All right. This is really important when the situation is really dire, the person's on a ventilator and is not going to come off. They are, already brain dead, but the ventilator is keeping them alive, That's very expensive. If you have a modest estate, that can eat away at your savings really quickly. We hear all the time about Americans, going in and getting tested for COVID-19 and getting a bill for $3,000, and they have no disposable income. One person went in the hospital, went on a respirator, survived, left the hospital, and got a bill for over $30,000. So it can eat away at your estate really quickly. If I was on a ventilator and in a vegetative state, I would want to say to the doctor, pull the plug, let me die. This is not life, okay? And it's just destroying our assets. But I'm on a ventilator, incapable of doing that. Your representative, if it is in the representation agreement, can have the authority to pull the plug. Okay. Tough choices, but if you don't do them, the consequences can even be worse. So that's a express agency relationship as well, because you are authorizing somebody to do something for you during your lifetime. The last document is called a comfort letter, and it is exactly that, a letter. Okay, it is not a legal document, even less so than the will, because it's not signed and sealed, or pardon me, signed and witnessed. What it is a letter that the person gives to their executor to help with the administration of the estate. If I passed away, I would like to think that my kids would be really upset. So if we had a situation where I passed away and my eldest daughter Bridget was handling the estate, she's already traumatized, okay? Now, she walks into the house and she says, okay, I wonder if Dad's got a will. I wonder where it would be. Would it be in a drawer? Would it be in a bank? I wonder where he banks. I don't know where he banks. Well, I know Dad and Mom had investments. Mom's already gone, so I wonder where the investments are. Do they have any life insurance? Okay, and this is not an unusual situation. I have a relative, sort of once removed, living in Australia. I didn't even know he was a cousin of mine. And he came breezing into North Vancouver one time, called me up, and he said, hi, you don't know me, but I'm a distant relative of yours. You don't know, but my mother lives in North Vancouver, and you're related to her, and she's passed away. And I want help with the estate. So I met with my distant relative, and he said, look, I'm an accountant. I work with a firm in Australia. We're in the middle of an audit. Things are really busy. I loved my mom. She loved me. We didn't see each other often enough, but gosh, we were still close. I cannot be here, so I would like you to do everything for the estate, and goodbye. And he got on a plane. He flew back to Australia. So I walk into my distant aunt's house, and that's exactly it. I didn't know if she had a will. I didn't know if she did have one, where it would be located. I didn't know where she banked. I didn't know whether she had life insurance. I didn't, have a list of her assets, and it was it was horrible. Okay, now I didn't have the trauma of losing a loved one because I didn't even know this woman existed, but it was still very upsetting. So consequently, have this comfort letter that you list, where your will is, where you bank, where you have investments, do you have life insurance, and then you can also get into what some people do is in the will. I did one will for Shane's father, and Shane's father had a watch, a gold watch that he was given when he retired from his job, and he wanted that to go to one of his sons, and then he had an autographed picture of Bob Hope, who you don't know probably, one of the all-time funniest comedian actors in the United States. And he wanted that to go to another son who really liked that photograph. And then he had some other, a ring that he had received from his grandmother that he wanted to go to one of his daughters. And and then the others, of course, and it was a big family, it was Irish, and there were others that were not going to get anything fancy. And so he gave them some money. And in the comfort letter, you don't put that in the will. I'm giving a Bob Hope picture to Daryl, so I'm giving $300 to Frank because he's not getting the picture. You don't put that in there. You just put in picture goes to Daryl. And the reason is you're dead. You don't want any conflict in the will because you're not around to say what you intended. So you put that in the comfort letter. Frank, I've given the Bob Hope picture to Daryl. I know that that you really didn't care for the picture, but I want to make sure that you know why I gave it to Daryl because he really likes it, and so as compensation that to show that I do love you as much as Daryl, I'm giving you some money, and you put that in the comfort letter as well, okay? And you explain why you're doing certain things. It's not a express agency relationship because it's not a legal document. You can and should update it periodically because your assets are going to change and your location of your banking is going to change and all those sorts of things. But with those 5 documents, you can at least have some order to what happens if you're incapacitated before you die and then right afterwards when you do pass away. Someone's going to say, well, a living will isn't on that list. And it's not on the list because I'm getting out on my soapbox here. I don't think it's really worth spending money for a living will. Living will basically says to the doctor, no heroic measures. Okay, so if I'm elderly and I've been in the hospital and I've been on medications and I'm fading away slowly and I have a heart attack, do not bother trying to resuscitate me. Okay. Well, first of all, the representation agreement should deal with part of the problem there. And then the other part of the problem there is it's unlikely that your family doctor, who you would give that living will to, will actually be there in attendance. Or if you do have it in a file at the hospital and there's a code blue and the doctors rush to your bed and they start preparing to resuscitate you, nobody's going to stop and say, okay, let's put this all on hold, just leave them there. Just leave them there while I go down and check the file to see if there's a living will there. So it may be of assistance, but I just don't think it's a particularly good use of your valuable funds. All right, so now there was one other thing that I was just thinking about when I did that, the heroic measures. Oh yes, I was just going to give you one example. My father passed away before the Representation Agreement Act came in, so I was not his representative. And the other problem was, of course, he's in a hospital in Victoria, and I was just there for the summer, and then I went back to Ottawa to finish my law degree. Well, it's unlikely that I was going to be there if a problem occurred. And he had talked to his doctor, and he said, no heroic measures. And the doctor said, well, Jim, I'm not going to be here when something happens. The odds are I'm not going to be here. So while I would honor your wishes, I cannot speak for the doctor in the on the ward that night. I'll put a note in the file, but I just want to warn you that that they may decide that it's their Hippocratic oath to, save you. So that I just don't think that that's a particularly necessary document. Okay. You take care of the estate as best you can. You use these 5 documents. It generally finds its way into my exam in some way, somewhere, because it's a nice 5-mark question. That finishes the lecture material for the course. I wish I was entitled to tell you more because there's so many other things that I think are really important, but these are, at least are the key factors that business people should take into effect when they're doing risk management. And estate planning, like everything else, is risk management. Thank you very much, and good luck on the final exam.